Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business before the court will draw near to give their attendance, and they shall be heard.
Good morning. Please have a seat. Welcome to the 4th Department. Just a reminder, I think we have a lot of usual customers, but just for those who haven't, the judges on the panel are all well familiar with the briefs, the record, and we know the facts to the extent that they fit into the record or into the briefs. We would ask that you not give us a recitation of the facts unless specifically asked by one member of the panel or others. We'd ask that you focus on your contentions in your brief, and if possible, give us the most important contentions that you can and really follow through on that. As a further reminder, we don't allow rebuttal, but we do allow, if you apply, for the opportunity to submit a post-argument submission. So with that, let's get started. The first case for argument is number 956, People v. Baker. 955. I needed my glasses, didn't I? There we go. 955.
Good morning. May it please the court. Krista McDermott on behalf of Jermaine Baker. I'd like to address points 2 and 3. Starting with the standard that should apply to the court's determination that Mr. Baker violated interim probation. We agree that it is clear that the pre-sentencing procedures from CPL 410 apply to interim probation cases. But the summary hearing procedure set out in Appellate is the minimum that is required for due process. So Appellate was saying that's the constitutional floor that courts can't go below. Courts can, however, go above it. And Appellate even suggested that in some cases it would be appropriate to go above it and apply a higher standard and conduct a more extensive hearing. So here the court did that. It was improperly characterized as a violation of probation hearing, but the court was clear that it was applying those procedures. And so the standard that it was applying was preponderance of the evidence, and that the violation cannot be based entirely on hearsay at this hearing that it was holding.
How is this, and this is a big question, and I realize it's going to get right, maybe require a longer answer, but how is what you're saying reversible error? That is it theoretically possible to say the court gave you more procedure or more process than you were entitled to? So where's the harm? Where's the improvement? Where's the reversible error?
Well, the error is that that this court should apply that same high standard and higher standard. And looking at the evidence under that standard, it didn't meet it. It was not proven by a preponderance of the evidence that Mr. Baker violated interim probation. With non-hearsay evidence. And that's because at the hearing, it was only a police officer who wasn't there for the incident. He could give mostly only hearsay about what happened because Mr. Baker's family members didn't want him to go back to jail and they weren't cooperating with the prosecution. And so
the other evidence that was presented, the daughter's injuries primarily. And we also had the knife and we had the head of the broomstick and some of the things that were mentioned. And then certainly the reactions by the family members, all three of the family members, the way that they were reacting when the officer got to the scene. Do those items, those non-hearsay items, do they have to be probative on their own? Or can they be considered in conjunction with the hearsay evidence that the detective offered?
So they certainly can be considered in conjunction with the hearsay, but they do have to be facts of a probative character, so that on their own, the non-hearsay evidence meets the standard of the necessary residuum of competent evidence. And here they didn't, because there was nothing that the officer observed that tied Mr. Baker specifically to any crime or any wrongdoing.
What about the injuries? I mean, the daughter, the bloody lip and her face bleeding and everything.
That establishes or shows that something happened to her, but it doesn't show that Mr. Baker was involved in it. And so
that's why I asked whether it has to be linked to the hearsay or whether it has to be probative on your own. I agree with you. If it had to be probative on its own, that doesn't get you all the way. But when you consider the testimony, my father kicked me or stomped on me because he was upset about my phone, you don't think that evidence is sufficient?
I don't, and I would say I think maybe this is a close case that maybe comes near the standard, but I don't think it meets it here because without the hearsay, it's really difficult to say that would have any connection to Mr. Baker at all.
What about the fact that the detective recovered the phone from Mr. Baker? And he said, he found it in his pocket. And he said, why do you have this on you? And he said, well, I paid for it.
I mean,
Cute response.
I think that would connect with the daughter's hearsay statement that her father took her phone, which is not in any way a crime. So I don't believe that the non-hearsay evidence is probative of Mr. Baker committing a crime, essentially. But in point 3, what we argue is even assuming that Mr. Baker did violate interim probation, it was an abuse of discretion for the court to kick him off interim probation and sentence him. And to be clear, this is not a harsh and severe sentencing argument that we're making. It's an abuse of discretion.
Right. Now, it's an interesting argument. Essentially, what you're saying is that when the judge found that, yeah, you violated probation because you committed this family offense, you violated your harassment, I think was a family offense. Technically, you did it. What you're suggesting in the brief is that the judge should have taken a step there and said, well, even though we have a violation, I still have discretion as the court to keep you on the interim probation. And more importantly, it sounds like from your brief, is not so much keep you on interim probation, but give you the opportunity to withdraw the plea to the sex offense, to the non-registrable offense. That's really the key to the whole thing, right? Because it's all about the SORA registration. But I didn't see that being asked for below. At no point did the attorney for the defendant say, Judge, we'd like you to use your discretion and to not, even though there's a technical violation, to still give the defendant an opportunity to withdraw the plea and enter the plea of the non-registrable offense. I never saw that request made below.
The defense counsel definitely requested that Mr. Baker be permitted to continue on interim probation.
Back in May, during the conference in May where they were trying to negotiate it?
Correct.
Right. Yeah, I saw that in the brief that you referenced the May 3rd hearing. And at that point, I think it was a different attorney. I think it was a former attorney. Mm-hmm. Former attorney certainly made mention of the fact that, yeah, we'd like to keep that opportunity, like to keep him on interim probation. And the attorney at that time was arguing, said, we don't even need to have a hearing. And that was, but I don't see on appeal that you're saying that the fact that the court had a hearing is a problem. So you're not challenging that on appeal. And then I don't see below you're asking for the judge's discretion, or the defendant's asking for the judge's discretion to keep him on interim probation or allow him to still withdraw the plea.
I believe you're correct that the second attorney never made that request, but I think that the first attorney's request would still preserve it, because at that point, essentially, she was saying, even assuming he committed a violation, we don't need to have a hearing, because even assuming he committed that violation, he should still be allowed another chance on interim probation. And if he completed interim probation, which he only had 4 months to go, then the plea agreement was that he would be allowed to withdraw his plea. So I think that request there was asking for the court to do that. And then the court explicitly denied it.
When all was said and done, couldn't he have still made a request to withdraw the plea? Even after the violation was done, couldn't he have made the request, say, well, we'd like to withdraw the plea based on everything that happened? And then based on some of the arguments that he has here, that I don't have the kind of history. I have a criminal record, but I don't have the kind of history that would normally lead to, a SORA registration. Couldn't that argument still have been made?
Yes, but I guess if he had asked to simply withdraw the plea, then he wouldn't have any agreement for interim probation or the endangering the welfare of a child or anything like that. It would be essentially just starting from scratch, which is what they wanted, was to let him go back on interim probation and actually get that deal that he was promised.
The deal that was contemplated.
Correct. I do believe that the court had the discretion to allow Mr. Baker to continue on interim probation, and that this court can review that decision for an abuse of discretion. And I think here what the lower court attorney said at that May appearance is that the consequences were so stark with regard to whether he was convicted of a sex offense and required to register for under SORA for the rest of his life, or he would have a non-registrable misdemeanor offense. And we certainly agree and understand that SORA is not part of the sentence and it's not part of punishment, but it's such an important alteration of someone's life, it is a consequence that the court should consider and that this court should consider. The Court of Appeals has noted that sex offenses impose a stigma that broadly impact a defendant's life and ability to participate in society. And SORA registration is really going to ruin the entire rest of someone's life, very likely. And here, the reason the plea deal was offered in the first place was so that Mr. Baker would be able to avoid SORA. This was his first sex offense. The complainant was nearly 17 years old. She told him she was 19. He only got 364 days for that crime, which I think shows that the court didn't think it was a particularly egregious criminal sexual act. And he only ended up being convicted of a sex offense because of this non-sex offense domestic incident. And so here, the actions that led to him being required to register for SORA really aren't commensurate with the extreme consequences that he'll be subject to. Thank you.
Okay.
Good morning, Your Honors. Elizabeth Dannon for the people. Addressing the first point that defense counsel spoke to, we would submit that this court's decision in Rollins is dispositive, that the procedures from CPL 410 apply, and we would.
You would rely on the Rollins. I think the argument that comes to mind for me is that we're not bound by a mistake of law.
Yes, Your Honor. In that case, the parties believed that the higher preponderance of the evidence standard applied, and the court said that they were mistaken, that 410 applied.
The one difference in Rollins, and this was cited by your opponent in her brief, is that in Rollins, what the court did is the court said, well, we're going to apply one standard, but then really applied the lighter standard, the Outley standard. And in Rollins, we said, well, the Outley standard was appropriate. It doesn't matter what the court said they were going to do. If the court applied the correct standard, that's fine. Here, the court applied the higher standard, held the people to the higher standard in that. Does that make a difference in your mind?
Your Honor, I do not believe it does. As was asked before, I don't think that the fact that there was a higher standard was applied and more evidence that was necessary was presented could in any way prejudice the defendant in this case. We would just submit also there was evidence of numerous other violations of probation, such that if the defendant had wanted to come forward with evidence of their own, that would have allowed for impeachment materials to be entered.
There was a negative drug test or a positive drug test.
Yes, Your Honor. And there was evidence that he had been abusing substances, and there was an active order of protection on behalf of his wife against him during the time of the interim probation. So I believe that the evidence, the fact that more evidence was presented than was necessary under Outley could in no way have prejudiced the defendant. Moving on to the SORA issue, Your Honor, I don't understand how it could be an abuse of discretion for the court to, that's not, SORA registration is not within the discretion of the court, of the sentencing court to begin with. It's within the discretion of the SORA court. So the excessive SORA argument, that is an argument that should be taken to the SORA court, an appeal from the SORA court's decision, I believe.
Do you believe that once the court found the violation, that the court did still have discretion to allow the defendant to withdraw the plea and then plead to the sex offense and plead to the non-registrable offense? I think it was endangerment of the welfare.
Perhaps so, but Your Honor, no such request was made, and there was a valid waiver of appeal was entered in this case, and also the defendant was thoroughly informed, was made aware during the plea that he would be subject to SORA registration if he violated the terms. It was clearly laid out on the record. There was no debate whatsoever about that. So, unless Your Honors have any further questions.
Thank you very much.
Thank you.
Next case for argument is number 956, People versus Lithoff. And I think counsel is by video and the respondent has submitted. Mr. Reed, you're muted.
Okay.
Very good. Mr. Reed, can you hear me okay?
Yes, I can. Thank you very much. And good
And we can
morning.
hear you just fine. Go right ahead, sir. Thank you.
Thank you. I think the most significant point in the brief was the first issue that I raised on behalf of the defendant appellant, which is the fact under rule, the presiding judge was disqualified based upon the judge's prior representation of the investigating agency, or one of the investigating agencies, in the matter, in that the court was a counsel for the Department of Social Services during the time frame of the incident, and that there were subpoenaed records where the court indicated, as I recited, that she was representing as a counsel for Department of Social Services. My submission is that
now, counsel, just to be clear about the facts concerning that 2018 issue, there was no proceeding. There was no neglect or abuse proceeding prosecuted by the judge's former agency, correct?
correct, and one would anticipate that that would be upon advice of counsel, so she would be representing.
That's not well, that to the extent that the judge did or didn't participate in anything in 2018, the only thing we have in the record is the judge's disclosure on the record as it relates to the judge's involvement in 2018, correct?
And part of the reason for that is the fact that the court unilaterally destroyed the record that the court was reciting without notice to defense. So I could not make that part of the record because the court had unilaterally destroyed that record. And you can see in the appendix the court's determination that it was going to destroy the record without notice to defense. So we cannot examine the record as to what the extent of the representation was. My submission, though, is that it would be similar to an assistant district attorney becoming judge and then sitting as the court in a trial matter where the assistant DA had access to the investigation at the time of the incident, whether or not a prosecution was pressed at that time.
Mr. Reed, let me just take you back to the statute, section 14 of the judicial law having to do with disqualification. And you've read the language. I think this is your main argument because everything else would be unpreserved, but the judge shall not sit as such in an action, claim, matter, motion, or proceeding to which the judge has been an attorney or counsel. What is the action, claim, matter, motion, or proceeding that you say this judge was attorney or counsel of record for?
My submission is that it's the rest. It's the thing that is now before a jury that the judge has represented in that matter. The matter is not yet brought to litigation, but it is the thing. It is the subject matter. It is the entirety of what is now before the court. So I'm asking the court here.
Forgive me for pinning it down, Mr. Reed, but as I understand your answer, you're saying that it is the criminal prosecution in which this appeal is related to, or that it came from. You're saying that the judge was an attorney in the criminal action that's before us?
No, I don't mean to communicate that. What I'm saying is that the matter that's before the court is the incidents, is the matter being investigated. It's the rest. It's the thing itself is now what's being prosecuted. And
we'll have to look at as to whether or not that's an action, claim, matter, motion, or proceeding, correct?
Yes, that it incorporates the initial part of what becomes an action or matter proceeding. Yes. Additionally, I was asking the court to examine the proofs in the indictment because the time frame is critical in the theory of the case that was presented. And the proofs that were submitted at trial place the act of sexual abuse either before or actually not before. Actually, as presented, the time frame is after the incident that occurred on February 13th. So the count of sexual abuse is not compliant with the assertions in the indictment as to when it occurred late January or early February of 2018, thus putting at variance the entire theory of the case. And I've submitted that with that in place, it draws into question whether this is the type of case under Collins and Lawrence that qualifies for the predatory sexual assault.
And that issue, you would agree, Mr. Reed, is unpreserved for our review, correct?
Yes, I do, which goes to the whole panoply of, I think, errors and omissions of counsel that should be taken into consideration, that the defendant appellant here received ineffective assistance of counsel due to all the recitation that I provided in my brief to you.
Okay, look at that.
I did want to observe, in matter of construction of the statute of 130.96 of the penal law, that at least in my review of the case law, I don't see an express construction of the statute. I do see that in my submission to the court is that, as referenced in Scott, as cited by Lawrence, that in Scott references that there are two elements of 130.96, and that the first element is to rape in the first degree. If subdivision 4 is included in that provision, the second element merges with the first element. And as a result, it makes superfluous all the other subdivisions of rape in the first degree. And I'm asking the court to consider that. But even in the absence of that, I would note its sentencing, the court provides a recital in the sentencing minutes that is not established by the jury. Those findings of fact that the court recites are not present, are not instructed to the jury to find. In fact, on the record, based upon the record, the court's recital cannot be established. So even under Ebola, where Ebola asserts that, or says that, the contention about these overlapping elements is where the contention is more apparent than it is real. The court recites there that it's because there are these additional guidelines that enhances the conduct, that supports the fact that there is a higher charged crime here. Additionally, Ebola recites the fact that there are disagreements about how this should be applied. And it does recite Black's dissenting opinion about the nature and extent of prosecutorial discretion, where there is no bright line guidance, and that can hide a certain kind of implicit biases that can be very easily cloaked and shielded, that should not be allowed. And so, my submission to the court is that it examine the construction of the statute that gives meaning to all of the subdivisions of rape in the first degree. And by taking out the subdivision 4, you're not saying it doesn't apply, because it is the second element in 130.96.
All right, Mr. Reed, anything else?
Nothing further. Thank you.
Thank you very much, sir.
That's on my papers. Thank you.
Next case for argument is number 957, People v. Heffernan.
Good morning, Your Honors. May it please the court, Phil Rothschild on behalf of Mr. Heffernan. First point I'd like to address is the lower court's error in denying defense counsel's request to inspect the stairways, or the stairs. Their condition was crucial, and the request focused on the angle and condition of the stairs, as well as the existence of any structural impediments. The defense was that she slipped and fell. That was consistent with her injuries, her prior history, the fact she was taking medication that increased the likelihood of falling, and her inconsistency.
We saw the video, the body cam video, and you can see where her kitchen is at the top of the stairs. And at first, comparing that video to her testimony at trial, it looks like she said that she started at the top of the stairs, and then she went flying and she fell down what appears in the video to be anywhere between 3, 4, 5 steps. Can't quite tell from the video how many stairs there are, but certainly from that kitchen door, her kitchen, there's about 5 steps, and it looks like you're in like kind of a wallpapered hallway going down the steps to a landing where then there's the door to the basement, where the police officers were standing for a bit, knocking, and then eventually they went through the door to the basement. So she says that she fell down that flight of stairs or was yanked down, and then she said, which is partial, when falling, I hit, which is partial of the cellar wall. Do you know what she's talking about there? I'm referencing page 51 of the trial transcript.
Well, given that we don't have, the video certainly, our problem with the video was it was dark and grainy and it didn't really show the stuff. And the problem with the photos is there are no photos. So I really can't answer that question, Your Honor.
Let me just interrupt you, Mr. Russ. That's caught my attention. I thought the people in answering the motion said that there were 30 photos provided, and I saw no rebuttal of that asserted fact by defense counsel. So very honestly, sitting here on this cold record, I looked at it as though the people did produce approximately 30 photographs that would show the stairwell and the basement apartment, but that's not disputed that they provided that. So on this record, it seems to me that what I can construe is photographs were provided along with the BWC. So that's an alternative basis to say that you had a chance to see it.
The only problem with that, Your Honor, is that we provided all the photos we received. We asked the district attorney multiple times, do you have any other photos? Everything was provided in the record we provided. I've looked through the photos. The only photo I saw of the stairway was an overview, which didn't show the stairs actually themselves. So as far as the claim that they provided these photos, I have yet to see them.
But it wasn't rebutted as part of the motion papers. That is, it's an undisputed fact from the people saying, we produced these 30 photographs. You would think if they hadn't.
The problem, yes, Your Honor. The problem is that the court relied upon this, and I would submit that it was wrong in doing so. It should have done its own investigation, should have actually looked at the photos that were provided, that we provided to this court as well. There's actually no pictures of the stairs themselves. So it was a failure of the court.
In the record, we have about 12 photos. I didn't count them. Might have been 10, might have been 15, but there weren't 30. About half of them were the victim's injuries. And I agree with you. I think I saw the one photo you referenced where you could sort of see it might have been taken from the top of the landing through the basement door to like the area, but you don't see the steps leading down to the basement.
Yes, Your Honor.
You also can't tell from the body cam video how many steps there are leading down to the basement, nor can you tell whether there was a railing on either the first set of stairs or those couple of stairs going down into the basement.
And the defense counsel also pointed out that even a photo would not be a sufficient substitute, because you actually have to inspect the stairs, because you can't tell how slippery the stairs are just by looking at a photo or any other type of things which the photo may not catch. Which the defense counsel was, the defense counsel should have said, hey, we never received any photos, but didn't say so. It was their fault for doing so. But the court also had the obligation to actually look at the photos before making this determination. Oh yeah, I see this photo here, this photo here, this photo here. Didn't do that. So the problem is inspection is common in civil cases. It's regularly done. Anyone who's done any type of civil litigation will know this. So the legislature adopted 245 basically to ensure that criminal defendants facing incarceration have at least the same access to evidence and the right to present a defense as people fighting over money. And that's why they did that. So the need for access looks at the risk the defendant will be deprived of relevant evidence versus the need for privacy and the existence of suitable alternatives. We've already talked about the alternatives, but the need for privacy would submit in this case was greatly outweighed by the fact that this was crucial evidence. Because if she fell, then basically their case falls apart. If there's additional evidence of that, such as the stairs being very slippery or very narrow or likely to to cause this type of fall, that detracts from their case and increases the likelihood that the defense was in fact correct.
Well, the absence of evidence might be helpful to the defense. That is,
except for the fact of what she testified to. That he did this. If you can show that these stairs are very slippery. By the way, her medical records show that she had prior falls as well, which is something that this court should obviously take notice of.
Mr. Rothschild, could this be harmless error?
I would submit that it's not harmless error because, first of all, the evidence in this case was, as I noted in point 2, was far from overwhelming. There was ample evidence that this what was testified to didn't really fit reality, didn't fit the facts of what occurred. But as far as the stairs themselves, it was crucial. I mean, the cases that the people pointed out, in fact, were easily distinguishable based upon the facts. Those are situations where the person had been there for weeks or months. Here, Mr. Heffernan was only there for a matter of days. Those are situations where the stairs were not relevant, here, where the property was not relevant. Here, it was incredibly relevant. And also there's situations where there was ample evidence introduced and shown to the court of suitable alternatives. And here it simply was not. So the proof in this case was was far from overwhelming.
Counselor, I mean, the victim's hands were, there was some binding here with wires.
That was claimed.
Right. So, I mean, would that be consistent with the alternative theory that she fell down the stairs?
If you look at the photos, Your Honor, the photos that were introduced upon stipulation of the parties, it shows bruising, but it doesn't show actual ligature marks consistent with that. If you look at her photos, yes, I think one of them was very red, some of the photos, but it doesn't show the actual ligature marks. But more importantly, is the other evidence which was claimed. The proof of the crime here was ambiguous at best, as the proof we submit is not even close to beyond a reasonable doubt. The prosecution's own doctor admitted that all of her injuries could have resulted as a result of falling down the stairs. I believe he said, yes, it's unlikely that you would have injuries only to your arm and wrist if you fell down the stairs, but that didn't obscure the fact that all of it could have happened simply from her falling down the stairs.
In watching the body cam video, you do hear his comment as he's struggling with the police officers, I had to restrain her.
Yes.
He has that, and that was pointed out. And I noticed during the summations that you may have objected or you interjected. I mean, it's a bench trial, but and said, I don't know if that's what was said. What did you think he said?
I think that he was on Ambien. So when you're on Ambien, you say a lot of, the police were positing because he was acting so out of it when they tried to rouse him, that was evidence of guilt. We would submit that's actually evidence of innocence because he had just gotten, I think only a matter of maybe a week or so earlier, he just had, I believe they testified to open heart surgery or some type of surgery, visible scars, blood. I mean, he even a complainant said he looked really bad. He looked like he was very, very bad off. And in the fact that he was taking sleep medication, which I believe was testified to in the PSR, the pre-sentence report. Yes, he was saying a lot of stuff which was, I apologize, my throat's getting very good. He said a lot of stuff which was strange, but all in all, it was absolutely consistent with innocence. She said, I restrained her, and that was objected to, so I don't know if that was actually said because it's not clear from the video. But more importantly is, what was the evidence that was there that supported this? Her own doctor said that taking Xanax increased her likelihood of hallucination and falling. The condition of the stairs, the investigation in this case was not very good. The police never really bothered to check the bed to look for pliers, which she said he threatened to pull her teeth out with. I mean, obviously, if it was there, that would certainly enhance their case, but they never bothered to look.
He was acquitted of that.
Well, I mean, as far as the criminal possession of the weapon, I believe he was convicted of the CPW, wasn't he?
Not of the pliers. I thought it was only with respect to the knife that was there in the chair.
And they found no knife because they didn't search for the knife. I mean, they found a knife, but they didn't find the knife. There was no blood or vomit stains on him. He had, after this occurred, he went right to bed. There's no indication that he took the time to dispose of the knife or dispose of anything, or he cleaned himself off. If he had done all these things that they claimed that he did, she claimed that he did, such as hitting her, he would have had something, blood or vomit stains on him, but there's no indication of that. He was, found in his bed, nothing on him, nothing on his sheets. Complainant's account just simply didn't square with the evidence. She claimed that he picked up a chair and hit her on the back, arms and legs, I think 9 or 10 times with it. He's a recent, surgery patient, after that, you're limited to what you can, the doctors say, hey, don't lift more than a gallon of milk. It's hard to believe that he did that. It was going up and down the stairs, but more importantly, if he's hitting her 8 or 9 times with a chair, why does she have no corresponding bruises? That's, there, and again, also no ligature marks. Her account was questionable. She initially told the police that she went down to confront Mr. Heffernan about him leaving nasty notes, and he followed her back upstairs and then he threw her down the stairs. But the thing is, even after they showed her making the statement on the videotape, she denied that she said it, which, you know, she also denied her prior medical history and the medications that she was taking. The likelihood, you know, so that all corresponds and correlates to Dr. Blumenty's analysis that she in fact did suffer from dementia because her prior history showed it. He, as opposed to the prosecution's doctor, he actually was a neuropsychologist. He wasn't just an ER doctor. He had a specialty in this. He reviewed all her medical records. Dr. Adcock did not, and he seemed very surprised by a number of things that were in fact relayed.
And Mr. Rothschild, this is all the information you've asked us to consider with respect to sufficiency and weight that's in the brief, correct?
Yes. Yes, Your Honor. The vascular ischemia, which is the increase of empty spaces in the brain, the prior falls, which Dr. Adcock said were eye-opening, the fact that she was taking Xanax and all this other stuff, the entire medical history, basic cognitive functioning, getting a 10 on the Montreal Cognitive Assessment Score, where 26 was normal out of 30. The concept of confabulatory filling actually explains a lot that went on in this case. When you get a brain injury, when you get a subsequent one, it's not just additive, it actually multiplies the effect. And in this case, she suffered from a subdural hematoma, which essentially scrambled her brain. So her brain was trying to make up for it. So what happens in those situations is the brain it will throw on all five senses. She imagined coffee being thrown on her. She felt the coffee. There was no coffee. He offered her coffee. That shows exactly how powerful this type of brain injury can be. And it shows why her testimony, in fact, you know, was just not credible. We would submit, in contrast, Mr. Heffernan's account made sense. He offered her stuff. She said, no, call my psychologist. He says, I'm going back to bed. And that's where they found him. They found him asleep in bed with no type of blood or vomit or any indicia of being involved in anything. So we would submit that the proof was both ambiguous and untrustworthy, certainly not remotely sufficient to establish proof beyond a reasonable doubt. And we would ask this court in the first case for the first point to reverse and grant a new trial, and for the second case to reverse and dismiss. Thank you.
Good morning again, Elizabeth Dannon for the people. So with respect to the first point about the stairs inspection, initially this request was made 3 days prior to the trial. So it was months after the after the incident had occurred, and there was no indication that the stairs were in the same condition as they had been at the time of the crime.
The statute just went in effect. It's a bench trial. So there's a couple of reasons why, you know, it's not quite as pressing as it otherwise might be on the eve of the trial. The other thing too is that the area that was going to be examined really wasn't the victim's apartment. It was the stairwell leading down from her apartment and then the steps going down into the basement apartment, which probably isn't even legal to rent out. So probably wasn't rented out at the time. Why wasn't it why wasn't it an abuse of discretion for the court to just say, yeah, go take a look. We'll put the trial off a week. We'll schedule an hour to go over there, take a look, photograph. If you want to have, because the real issue in the case was whether she fell on her own at first and struck her head, or whether she was thrown down as she testified.
Well, Your Honor, first I would suggest that the condition of the stairs wasn't relevant to whether she fell or not. The doctors, and there was no dispute that her injuries to her head were consistent with either being pushed or falling down the stairs. So the condition of the stairs, I don't believe would have been that relevant, but I do believe the court went thoroughly into weighing the factors, the statutory factors in that, you know, Well,
I think I agree with you that if she falls on the stairs and hits her head, or she's pushed on the stairs and she hits her head, that it doesn't matter as far as the injury to her is.
Yes.
But as far as the defendant's conduct, it matters a great deal, doesn't it? Because if she falls down the stairs on her own, he's not at fault. If he grabs her and throws her down the stairs, then he commits an assault. And that's what he
yes,
was
I do
convicted of.
believe that, Your Honor, but there's no real, her injuries are not going to speak one way or the other. His position was that she fell, hers was that she was pushed. So I don't know why the stairs are not going to speak, obviously, until what happened on that. I guess I'm not really understanding why.
The point is, if the stairs are unsafe,
Oh,
if they're narrow, if they don't have a handrail, if they're at different heights, if they're all the things that we see in slip and fall cases, if that's present here, does that maybe lean to the idea, or is that something that the defense could cross-examine the victim about and say, well, these stairs didn't have a handrail, these stairs are uneven, these stairs are whatever, there's part of it's missing on the step.
Sure. Yes, Your Honor. I believe that would be a good for cross-examination. I do believe that the video and the photos were sufficient to show that they were not, extremely unusual stairs. And there was, she hit her head on a cement wall. I guess it was a half flight of stairs that went down to the cellar wall, and then another half flight that went another angle down to the basement stairs. So impediments on those stairs, obviously, in the intervening months between the crime and the time of the trial would have been moved. So
Could have changed. Do you know how many
Yes.
steps there are going down to the basement from that first landing?
no, Your Honor, I do not.
Somewhere between 1 and 4, maybe?
Perhaps. And I,
What about the 30 photographs? Mr. Rothschild says there's no evidence to support that, but clearly the people represented to the court that there were 30 photographs that have been provided to the defense. What about those?
I did look at the photographs. I did see a couple photographs. My memory is a little foggy, Your Honor, but there were some photographs representing the stairs. I guess I would just argue that it's unpreserved if they are now arguing that there is not enough evidence of the stairs. But
Well, we're talking about photographs that are not in the record.
Right.
We know what's in the record.
Okay.
But we're talking about this idea that there's these extra photographs that are not in the record that were provided to defendant that showed the stairs. What's your position on that? No idea.
I do not know, Your Honor. So, but
What about harmless error on that issue?
I believe it's very much harmless error, Your Honor,
Why?
because her injuries were consistent with either falling down the stairs or not falling or being pushed down the stairs, so that it was just a matter of credibility, who the judge believed to be more credible with respect to what had happened. So that would be my position on that. And additionally, I would point this court towards the weighing of the statutory factors, the position of the individual with possessory right to the premises, and the fact that this would additionally victimize her as the victim of this case to have a further intrusion into her home, and the position of the prosecution against it. So weighing those factors, Your Honor, I do believe it was proper exercise of discretion for the court. And in addition, I would argue that it's harmless error, even if it was a mistake, because of the fact that the condition of the stairs, I mean, it could have resulted, her injuries could have resulted from a fall or from being pushed. There was nothing particularly probative about the stairs, I would argue, Your Honor. Moving on to the weight of the evidence and legal sufficiency.
The defendant's brief focuses on the argument that with respect to sufficiency, that the victim was incredible as a matter of law. That's how they get the insufficiency there.
Yes.
So getting back to your point, this case is about credibility.
Yes,
You would say the court was in a position to evaluate the credibility, and that
Absolutely.
gets you beyond the sufficiency as well as the weight. And is there more to it?
I believe that is absolutely true, Your Honor. I believe, this victim here showed that she was very credible. She told the police on the night of the crime, you'll find the key to the basement in the pocket of my bathrobe in my bedroom. She was very consistent with her details, and the brain injuries that she suffered and the damage that was noted in her very extensive medical records pointed to a lack of storytelling, that this impacted her ability to fill out details rather than, coming up with an elaborate tale of, which was what,
The pillow.
what
But the pillow.
the pillow, she said he
With
threw
all the blood on it.
yeah, she said he threw something soft at her. She recognized it as, the pillow from his bed. She spoke repeatedly about him throwing something cloth over her.
She never said he put a pillow under her head. And that looks like where the blood and the vomit were.
Mhm.
And that seems inconsistent. You don't think that's inconsistent with her testimony?
Well, Your Honor, I believe that, a lot of things were happening. I believe that he did drag she said he was extremely disgusted by the blood and the vomit. And he was, they were having an altercation. He was arguing with her, and he was believing that the house was bugged. He was paranoid. He was looking at the evidence, Your Honor, I would suggest the defendant here was the delusional one. He was, he was cutting wires out of the ceiling. He had tinfoil over the windows. He was accusing her of the house being bugged. He was very disgusted, and he was throwing things over her. Obviously she's been fallen down the stairs in shock. She's, a lot's going on. Maybe she didn't.
So you think the evidence that the police found when they went down there and they saw the pillow with the blood and the vomit on it, as is on the bottom of the basement stairs, you think the theory that people have is that he put the pillow on top of her and that somehow she got the pillow off her, and that's how the blood and the
Yes, that's one. Yes,
that's as opposed to him putting it under her head before she threw up and as she's bleeding in order to give her some sense of comfort.
yes, Your Honor. Yes, Your Honor.
And you thought it looked like that?
I think it's consistent with that, Your Honor. And I also believe, seeing the wires, the rubber coated wires, which would not leave ligature marks, but I thought that was very significant also that those were there. The fact that, this occurred in a kitchen explains why a particular knife wasn't, attested to as the crime weapon. And additionally, with respect to, the defendant's inability to, physically accomplish these, pushing her down the stairs and hitting her with a chair. It took 2 policemen to subdue him. I mean, he was obviously in good enough shape where he could successfully resist 2 grown men. So I don't think, him, a small woman was not going to be too much of an issue for him. And additionally, the fact that he, no blood or vomit, he was disgusted by the blood and vomit, and the police found him stark naked in the bed. So he'd obviously taken everything off. So any blood and vomit would have been gone by that point. Your Honor, I would just, and obviously the court was in the best position to evaluate credibility. So unless Your Honors have any further, thank you.
Roll set. Thank you. Next case for argument is 958 People versus Brett. Counselor, good morning.
Good morning, Your Honors. May I please the court?
By my count, you have 7 contentions in your brief, thereabouts. And I'm wondering where you're going to take us first.
I will focus on point 2 today. Thank you. So Mr. Brett had only one defense, is that he didn't start the fire, but the court prevented the jury from hearing about it. The brothers, which is the sole eyewitness, opinions that Mr. Brett looked like he was set on fire was not speculative. It's irrelevant that the brother did not actually watch the fire. You do not need that. Otherwise, I think I would be arguing at the direct evidence of who started the fire and not opinion evidence. Here it was sufficiently based on the brother's personal perception. He saw Mr. Brett on fire, and that's what he explained in his testimony to the police, based on how Mr. Brett was on fire and how fast his clothes were burning.
Let me catch up where you are. Just bear with me here. You're talking about the testimony exacted from the brother?
The testimony of the brother?
The brother, right?
Yes, that's correct. Yeah.
And that's what you're on now, saying that he should have allowed them to testify as to what he thought happened or could have happened.
That's correct. Yes.
Okay, go ahead. Thank you.
Yes, I think it was just proper lay witness opinion evidence, because it was not just a speculation from the brother. He said he saw Mr. Brett coming down the stairs, and he saw how he was fully on fire and how fast his clothes were burning. And based on that and his knowledge that only the decedent was upstairs with Mr. Brett, it's possible that she might have thrown something at him and started him on fire.
Let me carve this up a little bit for my benefit. I'm not sure it's going to make sense, but the jury heard the testimony that you just described, right?
That
Then the question is, would they hear the opinion from the brother vis-a-vis what may have happened or may not have happened? That is, he was giving the potential for two different versions. One is he started it, one is she started it. Now, that would not be fact testimony because he did not observe it, correct?
That's correct.
So it could only come in as opinion testimony.
That's correct.
And even a lay witness seeking to offer an opinion has to have some basis in fact or experience, correct?
Yes, that's correct.
And what does the record reflect with respect to any experience that the brother had to be able to testify as to how the fire started? I don't see that in the record. You can see why I would think that's a deficiency.
I understand that. And I think the rule of evidence are really clear that either you need to have, the witness need to have some personal experience, or it has to be within the ambit of common experience. And I think here we do have we do have an opinion that is sufficiently based on common human experience. And he didn't say he's not an expert. I agree with you. But he does not need to actually have experience with fire or even have, as I think the people argued, experience with his sister setting up a fire. I think in the case law, when we look at lay witness opinion experience, lay witness experience, we are talking about just what we can all agree and like. And also, it was an opinion about the physical condition of Mr. Brett. It was just...
Counselor, if I can, he knew it was fire. He didn't need an expert to tell him
That's correct.
that he was on fire.
That's correct.
He understood he was on fire and he observed the defendant on fire. And
That's correct.
that's your point is, it's not a long leap for this witness to conclude somehow this is what might have happened, how he got.
That's correct.
How he became on fire.
That's correct. I think that's correct. I think it's within common experience to be able to say, oh, somebody looks so much on fire, they're so fully engulfed in flame, which was a testimony here, that they had an accelerant thrown on them compared to they were burned by an adjacent fire. And I think that's really the point that is within common experience. And I think it's very comparable, for example, to this court when they decided that a bite mark, like somebody can, testify about a bite mark. You just see the teeth mark. You don't need to have special experience or even having to be bite before. You can just say, oh, based on common experience, it was a biting. And I think that's really comparable to the situation that we are here.
Let me switch gears a little bit because I think I know what's coming in from the other side, but so you get a chance to address it. Didn't this testimony, the lay opinion testimony that you think should have come in, didn't it ultimately come out in some substance through another witness or witnesses, a police officer testified about what the brother said? Didn't the jury ultimately hear that testimony?
So that's correct that technically the jury heard that part of the testimony, but it was not allowed for the truth of the matter, of the actual opinion of the brother. It was just allowed for, as a hearsay exception, effect on the listener, why the investigator did not, I think it was ask further question or like how he conducted his interview of the brother. And so I think if the respondent position is that it's harmless because they heard it anyway, I don't think it's correct. I think here the ruling was very clear that it was the opinion evidence for truly the inference that the jury could have drawn. Oh my God, the brother of the descendant, which is the sole eyewitness, saying that it's possible that the descendant started the fire and it was not Mr. Brett. And
as I understand it, you're basically saying this information was so critical to be heard, it had to be heard from the source.
I think so. I think knowing that, and it was not in a vacuum, Mr. Brett, and that's why it's not harmless. Mr. Brett introduced different type of evidence, like material evidence and expert evidence, that it did not start the fire. Both the descendant DNA and Mr. Brett DNA were on the gasoline bottle and on the lighter. The fire marshal said that Mr. Brett could have been also a full package. So at the origin of the fire, and the nurse testified that his back injury were not consistent with the people's theories that it was a fire flashing back at him. So I think here it really curtailed his defense, because there is a reasonable probability that if the jury had heard from the brother, from the sole eyewitness, that theory, they could have had, or like, look in a different way at this other evidence. And the last thing I would like to add briefly is that I agree, we're just talking about admissibility here. I agree that the brother was not a witness, and I agree that maybe he was wrong, and he does not truly know who started the fire, but it doesn't have anything to do with admissibility. It should have just been admitted, and then the people could have crossed the brother about the weight of his opinion. And if there
Which
is,
was their own witness.
yes, correct. That
And
was,
one's own witness is typically not allowed, but that's a different issue.
I think that's a different issue. And here, I think it's really a constitutional error to prevent Mr. Brett from at least having the jury hear that.
Okay.
Thank you.
Thank you.
Good morning, may it please the court and counsel, April Orlowski for the people. This statement of Mr. Altmos, who was the victim's brother, was not just that he saw the defendant running down the stairs in flames. It was that he saw the defendant running down the stairs in flames, and that Bell, who was the victim, might have thrown something on defendant and started him on fire for coming back, because the victim and defendant had broken up a few weeks before the fire. They had been a couple and their relationship failed. The problem with Mr. Altmos' statement that he had given the morning after the fire, so just maybe a few hours after, to investigators, when he didn't have an attorney present, anyone present, was that exactly what Your Honor Curran said, is that lay witnesses must have some basis in fact or experience. He wasn't just testifying that he saw defendant running down the stairs in fire and that he was on fire. He was also saying that Bell, the victim, might have thrown something on him and started him on fire as well. When Mr. Altmos saw the defendant on fire, he was sitting downstairs in the home. What had happened took place upstairs in the home. Mr. Altmos was at no time upstairs watching what happened or listening to what happened between the defendant and the victim. He simply saw the defendant come in the back door, go up the back stairs, heard like loud sounds like something was falling down, and then 20 to 30 seconds later, saw the defendant run down the stairs in flames, threw some water on his front. The defendant rolled on the floor in the kitchen till the flames on his back went out, and then he left. So the only evidence Mr. Altmos has is that he saw the defendant running down in flames. He was not present on the second floor.
No, go ahead, please.
His testimony on direct was he was fully engulfed in fire.
Yes, John.
His jacket, his jeans,
Fully engulfed.
his everything.
Mm-hmm.
So the basis of the opinion, and you've suggested that maybe the basis of his opinion that his sister had thrown an accelerant on the defendant was based on their fighting. And
Yes.
we had that too. All the text messages and everything else came in too. But it was also the way that when he first saw the defendant coming down the stairs, fully engulfed in fire, that was also the reason why he thought that at first.
That's why he thought that.
He was able to testify to that.
He testified to that. That was his statement that he gave to investigators. That statement, he did not testify to it. What was allowed to happen was that statement came in through the testimony of the lead detective, the Buffalo police detective.
You mean the opinion then?
The opinion, yes,
Right.
I'm sorry. So that opinion came in through the testimony of the lead detective on the case. And that was an effect on the listener hearsay exception. It came in that way. But the fire marshal, before he started, there was a stipulation between counsel that statement came in with no limiting instruction given. So that statement came in without any limiting instruction. So the jury heard the whole statement. They were free to make whatever association or whatever they wanted to believe out of that statement, that
the victim threw fire on or threw some substance on the defendant and set him on fire. If they chose to believe that, they heard the statement without any limiting instruction whatsoever. So if that's,
So if the judge should have allowed it at first, the judge ultimately allowed
he
it.
ultimately did. So what happened here is not common experience or something that the lay witness saw. This is not common experience of someone lighting a campfire or lighting a fire in their backyard to burn garbage or sticks. This is setting an individual on fire. And as far as I am familiar with, Mr. Altmos has never had any experience of doing that. So this is not a simple, well, he just has the experience of lighting a fire. That's not what happened here. This is not a fire that simply started upstairs at Manhattan Street in Buffalo, New York that day. This was arson and a horrific crime.
Your essential point, as I understand it, is that there's no factual basis or experience basis for this witness to be allowed to offer that opinion.
Exactly. And besides that, the opinion came in anyway with no limiting instruction. Unless your honors have any further questions for me, I'll rest on my brief.
Thank you.
Thank you.
Next case for argument is number 959, People versus DeWolf. Appellate's counsel, Mr. Keene, is remote, and then Ms. Mickowitz is here, I believe. Mr. Keene, can you hear us okay, sir?
I can, Your Honor.
We were expecting an appearance by the respondent. I don't see anyone here, and they haven't checked in to our knowledge, right? So looks like you're solo, Mr. Keene, on behalf of the appellant. Go right ahead, sir.
Good morning. May it please the court, Brad Keem for Mr. DeWolf. Even if this court finds the waiver valid, we'd ask it to review the sentence pursuant to Hannah T. A lesser sentence for Mr. DeWolf, who was 22 at the time of the offense, was appropriate considering the several mitigating circumstances that we raised in the brief. Unless there are questions about those circumstances, I'll rely on my brief for that issue and the other issues that we raised.
Great. Thank you. I don't think we have any. We're all set, Mr. Keene. Thank you.
Yep. Thank you.
Moving next to number 960 in the matter of Jonah M. We have the AFC, Ms. Davis by video. The other counsel have submitted.
Can you hear me?
We can. There you are, Ms. Davis. Good morning to you.
Good morning, Your Honor.
We can hear you just fine. You're solo here today as the AFC. We're prepared to hear your argument.
Well, I guess I'll make it short for you. The appellate has been in prison most of his life. Even at the time of trial, he still had another 4 months left on a felony sentence. My client will be 5 years old next month. And by the appellant's own testimony at the time of trial, he's seen that child face to face only 4 times between December 8th of 2022 and February 28th of 2023.
Counsel, I couldn't tell from your brief. Are you substituting judgment for the child, or is the child expressed that he wants no contact with the father? I can't tell either way.
I did interview my client. I did have an opportunity to as best I can with a 4-year-old at the time, but I would say it is a little of both, Your Honor.
Well, he's almost 5 now, right? He's
Yeah, that is correct. Next month.
5 next month.
Yes.
The other concern I have, just from your brief, you have on page 36, you're talking about the father, and you say, contrary to appellant's hubris, rightly or wrongly, he'll be treated as a convicted felon by society.
He
It
claims.
is hang on, the next is the one that bothers me. It is inconceivable that he has the wherewithal to overcome societal bias to successfully rear children of a tender age. And I'm just worried if this applies to everybody who's incarcerated, if they all now should be written off, we should write them off and they shouldn't be parents anymore. Is that what you're saying?
Absolutely not. Absolutely not, Your Honor. My take on this particular appellant comes from his lack of awareness of what is going on. Everybody is trying to help him. Everybody is trying to help him, Your Honor. And he's on the telephone with a 2-year-old at the time. He's on the telephone, a child that he has never met, a child he has never seen, a child that does not know him. And this child is eating cereal, not really paying attention to the phone. He's telling the child that he's never met and that he doesn't know that in 2 years' time, he will be able to take care of him.
All right. Well,
Okay,
first,
he will buy a house and he will take him away from everybody. And
right.
everybody that is trying to help him.
All right. Couple things. First of all, you weren't on the call. This was in May of the year when the father was incarcerated. The child was 16 months, not 2 years, as the witness testified to inaccurately. You weren't there on the call, and you're basing this on the testimony of the DSS caseworker or DCFS caseworker. And the DCFS caseworker made progress notes about this phone call too. This was the only phone call he was allowed to have with the child listening. And he's in prison on a phone. Like, he can't see the child. He has no idea if the child's even there. He's just trusting the DCFS worker, right?
Yes.
And you're claiming that what the DCFS worker testified to 2 years later, what she recalled from that phone call with the child eating the cereal, that's the basis of why he's going to lose his parental rights?
The basis why he's going to lose his parental rights is that he can't stay out of prison.
Okay, so then if you have a person that's having trouble staying out of prison, does the DCFS in your mind have to make any diligent efforts at all?
And they did.
No. First, do they have to? Then
Yes.
we'll talk about if they did.
Yes.
They still do have to. Okay.
Yes.
What do they have to do other than encourage the one phone call or allow the one telephone call that he had while he was in prison for the 9 months? What do they have to do?
All of the things that they tried to do in setting up the telephone calls, setting up the video, which did not happen because Cayuga Correctional did not allow the video.
Hold on. It's your position that they actively tried to set up video calls with him.
Yes.
Where do you base that after looking at those form letters and after looking at the progress notes? Where do you base it that they tried anything to set up either the video calls or the live calls?
There would be no other way that they would know that Cayuga Correctional would not have allowed that had they not attempted to set that up.
Cayuga Correctional allowed live visits, and they were working to getting the child there during the week. And the DCFS caseworker was the one who didn't support that. It's clear from the progress.
Well, that's kind of on to the appellate's point. That's kind of on his counsel's part too, that he never submitted an order to the court for those visits.
Now, counsel, you're not really here to talk to us about the efforts made by the agency here, right? You're here to talk to us about the best interests of your client, correct?
That's correct. But the thing is that my client only knows his maternal grandmother. His maternal grandmother has taken care of him since, well, the record doesn't say, but since birth, since he was born in January of 2021. I mean, we're looking at the TPR timeline from February of 22 to February of 23, again, where the father was imprisoned, but he only knows his maternal grandmother. He lives there with her. His stepbrother is there, and he's safe. He's happy.
Counsel, this isn't a custody case. Counsel, this isn't a custody case, though. I mean, if the father, whether the father loses parental rights or doesn't lose his parental rights, the child's still going to be spending 99% of his time with his maternal grandmother. She's going to raise him or raise the half brother. None of that's going to change, right? This is just about whether the father has any parental rights at all, whether he can send him gifts or toys as he tried to do for the limited period of time when he was out of jail. That's all this is. We're not talking about custody, are we?
But the thing, to go back to your earlier point, the thing is that even when he was out, he did not avail himself of all of the services. By his own testimony, he did not complete anger management. He did not do a mental health evaluation. There are services that were also offered in the prisons that he did not or maybe could not avail himself of.
From where do you draw that conclusion? That there were services offered in prison? Because no one testified at trial about any.
No one testified because apparently there were long wait lists, was his testimony.
Yeah.
But there were services out of prison that he did not avail himself of. And he testified that he did not complete anger management or the mental health evaluation.
But you're talking about when he was in jail or when he got out of jail?
No, when he was out.
I said, okay. And you don't think that he took any steps when he was out to try to comply the domestic violence training that he began, the 3 classes? None of that impressed you?
Overall, no.
Ms. Davis, anything further?
I have nothing further, Your Honor. Thank you.
Thank you very much. Number 961 is over the term. 962 is fully submitted. 963 is over the term, as is 64. 965 is submitted. That brings us to number 966. Broden versus County of Onondaga et al. The appellant has submitted. According to my list here, once everybody gets up here, we're going to start with Mr. Powers. And Mr. Powers, good morning, sir. You represent Mr. Owens, correct?
That's correct, Your Honor.
Go right ahead.
All right, good morning. Thank you. May it please the court. I'm Christopher Powers from Mackenzie Hughes Law Firm in Syracuse, and I, as you mentioned, represent Dwayne Owens, who at the time of the events in question was the Director of Personnel for Onondaga County. As appellant has not appeared here this morning, I'll keep this pretty brief and primarily just rely on my brief. Obviously, we believe Supreme Court's ruling should be affirmed for the reasons detailed in the pretty thorough decision issued by Judge Gilbert. The only thing I'll reiterate is that defendant Owens provided evidence showing that he's entitled to summary judgment. Appellant was required to present evidence in admissible form to contest that, to show an issue of fact exists to support his claims of retaliation and conspiracy, and presented essentially nothing other than speculation and conjecture, which is clearly well settled that that's not enough to overcome summary judgment. So therefore, the court's decision should be affirmed. And unless you have any specific questions, I will yield the rest of my time.
We're all set, sir. Thank you.
Thank you.
Next up is Ms. Felter. And Ms. Felter, you're here on behalf of attorney Stephen Williams, correct?
That is correct. May it please the court. Karen Felter from the Smith-Sovic office. And I am in fact representing Steve Williams, who is my partner. He has been named as a defendant in this case. And as aptly stated by Attorney Powers, the attorney for the plaintiff has never come forward with any actual facts or allegations to create any material questions of fact concerning any of the defendants, but most particularly Mr. Williams, who wasn't even involved in the underlying events that were part of the Board of Ethics complaint. His role was solely and exclusively to investigate that Board of Ethics complaint, which he did. His report speaks for itself. All of that is detailed in the record, in the court's very detailed and thorough decision. And as again stated by Attorney Powers, The plaintiff simply did not meet his burden of proof. So the,
Primarily, according to your brief, it appears on the element of causation is the biggest issue.
well, I think he has a problem with with all the elements, certainly, but yes, causation, most certainly. There's just literally no evidence, not even a fact or a suggestion of a fact that has ever been uttered in the case to create any sort of connection between the manner in which Mr. Williams conducted his investigation and some effort to assist the district attorney in his election or some improper motive. I mean, there's just literally never been anything stated. It's just been a besmirchment, frankly, of Mr. Williams' fine reputation as an attorney in the state. So with that, I think I'll rest unless there's any questions.
I think we're all set, Counselor. Thank you.
Thank you.
Last but not least, Mr. Di Benedetto.
May it please the court, Donald DiBenedetto for District Attorney Fitzpatrick. Again, I'm going to repeat what's already been said. There is absolutely no evidence in this case to support the claims of the plaintiff. This arises from the plaintiff's request made on his behalf to be appointed captain of the police department. That request was denied by Commissioner Owens for reasons that he explains in very detail, both in his sworn testimony to Attorney Williams and the investigation of the ethics complaint. There's no indication at all, no evidence whatsoever that DA Fitzpatrick had anything to do with the determination by Commissioner Owens. In fact, there's no evidence in the record that DA Fitzpatrick even knew that this request was being made to appoint the plaintiff as police captain. The plaintiff did nothing after Mr. Owens made his determination for 17 months and then filed an ethics complaint against DA Fitzpatrick, which he recused himself because he was on the Board of Ethics. An investigation was conducted by Attorney Williams. The plaintiff didn't cooperate with that investigation and then waited another 3 years to commence this action. So not only is there absolutely no evidence to support the allegations, they're all time barred, and for many other reasons, as set forth in our brief, the decision below should be affirmed.
Thank you, sir. All set on that one. Next is number 967, Sposato versus Village of Solvay et al. Our records indicate that the appellant has submitted, and we're now with Mr. Di Benedetto, who's didn't have to go far. And we have then Mr. Cartwright by video, as I understand it, and let's just wait for him to patch in. Here we are, Mr. Cartwright. Good morning, sir. Can you hear us okay?
I can. Thank you.
We can hear you just fine. We're going to have Mr. Di Benedetto take it, and then we'll go to you.
Sounds good.
May it please the court, I essentially will rely on my brief. I think it's very clear that the plaintiff's claims, they don't border on being frivolous. They're completely frivolous. They've been evaluated in a federal court action that involved the same issues and the same parties. And in the federal court case, Judge Sotheby dismissed the complaint, the amended complaint. Actually, he also determined that there would be no permission to amend or assert any causes of action arising from these events. And what Mr. Sposato then did was sue essentially the same parties under the same theory in state court. And Judge Lamondola properly dismissed those claims under theories of res judicata and collateral estoppel. So unless the court has any questions, I'll rely on my brief.
I think we're all set. We'll hear next from Mr. Cartwright, sir. Thank you.
Your honors, may it please the court. I would rest on my papers as well. The appellant hasn't shown up to give any sort of oral argument for me to rebut. I agree fully with Mr. Di Benedetto. I have nothing further. Thank you.
Thank you for making yourself available. Thank you, gentlemen. All set. Next on the calendar is number 968, Sparks versus Kendra. And I think your opponent, Mr. Goldbus, is appearing by video. Let's just wait for a second for him to be patched in here. There you go. You're off mute. Can you hear us okay?
I can, Your Honor. Can you hear me?
We can hear you just fine. So we're going to hear from the appellant's counsel, sir. Thank you.
Terrific. Thank you.
Good morning, Your Honors. My name is David Goldbest, and I represent the appellant, who is a widow whose two IRAs that were kept at Morgan Stanley were incorrectly awarded to her by the surrogate to her stepdaughter. The widow has produced in this record an inked and acknowledged beneficiary designation on both IRAs, both Morgan Stanleys. Those were in the record. And they provided that a clear indication that the decedent wanted her to have these IRAs. What's more, they complied with the rules of the EPTL 13-3.2 and with company rules that say these have to be on our forms and in a manner that we prescribe. It also comports with the Court of Appeals decision in the McCarthy versus Aetna Life Insurance, which held that any beneficiary designation has to be on company forms. And in particular, the McCarthy case addressed change of beneficiary.
So Counselor, didn't Morgan Stanley accept the beneficiary forms?
I cannot say for sure that they did. They produced statements that said that the change of beneficiary, that said nothing, that said now the stepdaughter is the owner.
Right. So there was a change as a related, I mean, Morgan Stanley is the entity that made that change.
Yes, but I don't, I cannot see on this record.
I guess is maybe not your claim then against Morgan Stanley?
No, respectfully, my claim is that the surrogate improperly awarded the IRAs to the stepdaughter when there was no proof that Morgan Stanley rules were followed. McCarthy says that the company designated forms. Well, now we're dealing with the electronic forms because the stepdaughter designated, or someone designated for her benefit, a change of beneficiary that was electronically produced, that was e-signed. But Morgan Stanley has very specific rules. Those are in the record from the letter of its vice president, and they are also in the record of the brochure of Morgan Stanley that explains how a person is to effect electronically a change of beneficiary.
And that's really, as I understand it, the heart of your brief. It seems to me you asked for us to flip it the other way and award these accounts to you because your argument is first that as a matter of law, it's so clear that Morgan Stanley didn't comply with its own internal rules that you should win and have the accounts assigned to you. Alternatively, you're asking us to say, find a question of fact on that because we need to explore vis-a-vis Morgan Stanley why it is there's a statement that has the stepdaughter's name on it in 2024, and yet they didn't, according to your argument, follow the rules that they have established. And I don't mean to steal your thunder, Counselor, but it seems to me that's what you've teed us up for the review, right?
That's correct. Either there should be a reversal and an award in favor of the widow, or there should be a hearing. We specifically asked for a hearing on the issue of which beneficiary is correct. Where did Morgan Stanley go right and where did it go wrong? I would note that there is nothing in this record. 1,862 pages of documents were produced by Morgan Stanley, and we showed them to the surrogate. Those records are devoid of any proof that Morgan Stanley followed its own rules, or that the respondent stepdaughter followed those rules, or that the decedent followed those rules. There is no record that he deliberately, consciously, and comprehensively followed those rules. He didn't follow them. There's nothing in this record that says that he received an email, or that he punched a certain button, or that he exercised these particular options. These are all the electronic signature requirements set out by Morgan Stanley. So was there an acceptance by Morgan Stanley? We don't know because there's no record by anyone in authority at Morgan Stanley that says we have received all 6 steps from.
Well, you don't own it. Your client doesn't own it, right?
Well, the record doesn't have any affirmative statements, sir, that Morgan Stanley has acknowledged that the decedent followed its rules.
Okay, so for all your argument is, yeah, we do own it because it didn't follow the rules. Okay, I misspoke. I got it. Okay.
And the case came on a cross motion by the widow that says in the failure of the stepdaughter to produce any proof authenticating the e-signatures, she loses on summary judgment. But if the court finds a question of fact, then we should have a hearing. We should bring in the people from Morgan Stanley and have them explain what is in the responses to subpoenas and what is in their records. I should think that the responses to subpoenas were comprehensive, 1,862 pages. But here, I searched that record. I could not find any authentication of the e-signatures. But because we put that forward on a cross motion for summary judgment, the burden then passed to the stepdaughter to find ways to authenticate. The issuance of the statements in the name of the stepdaughter is therefore ambiguous and equivocal. We don't know why Morgan Stanley started to issue these statements in the name of the stepdaughter. It happened 8 months after death, at least. It happened a long time after the company had begun issuing, or it had continued after death to issue statements that showed the benefit to the widow. The issuance of statements by themselves don't determine the case.
Okay.
And that was the surrogate's hinge. That was the basis of the surrogate's argument. This is a case of first impression. And I would urge this court to consider that old people like me need protection from e-signatures. We need to have a rule in this court and in the New York courts that protect people from making mistakes on designations such as these that are so important, or having someone prey on them and make mistakes against them.
We'll probably focus mostly on the facts in this case, Counselor, but your point is well taken. It's understood.
Thank you.
Thank you. Now we'll hear from respondents, Counsel.
Good morning, Your Honor. May it
morning.
please the court. My name is Todd Lascaretz, and I represent the respondent Kathleen Sparks, who was the daughter of decedent Henry Sparks, whose accounts, IRA retirement accounts with Morgan Stanley are at issue. Cutting to the heart of our argument is set forth in our brief. It's our position that there was substantial compliance by Morgan Stanley when it affected the change. There was substantial compliance by it with its own rules. It is clear from the record that Mr. Sparks unequivocally contacted Morgan Stanley, his Morgan Stanley advisor, to advise that he wanted all of his accounts at Morgan Stanley, the beneficiary, changed to his daughter, the respondent, with no alternative beneficiary. The account advisor then contacted other Morgan Stanley personnel, and the necessary documents were prepared. In the record is the designation of beneficiary of Kathleen Sparks on each of these accounts, which was prepared by Morgan Stanley. It was signed electronically as permitted by Morgan Stanley's rules. We rely on the Court of Appeals case of McCarthy versus Aetna, which determined that strict compliance with prescribed methods for changing beneficiaries is not always required. The paramount factor is the intent of the person who is changing the beneficiaries. And if he has made his intent known to the financial institution and then cooperated with the financial institution in effecting the change will be affected. So long as there is and has been substantial compliance with the rules. So here, as the Court of Appeals made clear, the rules were made by Morgan Stanley, by the way, for its own protection. And Morgan Stanley is not a party in this. And if the complaint, which seems to be with Morgan Stanley, they should have been made a party if that's what was what appellant's gripe is. But my client had no involvement with effecting the change of beneficiary. That was done at Mr. Sparks' request by Morgan Stanley and as set forth in McCarthy. Morgan Stanley certainly was free to waive strict compliance, which the appellant raises certain what I understand to be technical objections, which the surrogate, I think, correctly said were, if anything was done incorrectly, it's a matter of conjecture and so forth. So,
And getting back to your other point, Counselor, if it was done incorrectly, it was done incorrectly by Morgan Stanley, for example, on the one account which wasn't transferred, and your client did not get. And your point, as I understand it, is if you have a problem with Morgan Stanley's procedures and they transferred it wrongly, sue Morgan Stanley.
Absolutely. Absolutely. But as far as the two accounts at issue here, there was certainly substantial compliance. It was the changes appear in the record on Morgan Stanley forms, and the changes were affected by Morgan Stanley and accepted by Morgan Stanley. And so that's where we are. Everything was done correctly. And if appellant has a complaint with Morgan Stanley, they should have sued Morgan Stanley.
We will take a look at the briefs and record. Thank you very much.
Thank you very much, Your Honor.